Hello everyone, so myself Gaurangi Kushwah, and today in this video we are going to discuss about nuisance and torts. So let's get started. So first of all, a person in possession of a property is entitled to its undistributed employment as per by law. However, if someone else improper use of enjoyment in his property ends up resulting into an unlawful interference with his enjoyment or use of that property or of some other rights over it or in the connection with it, we can say that the tort of nuisance has occurred. So the word nuisance, one second. So the word nuisance is derived from the old French word nuire, which means to cause harm or to hurt or to annoy someone. In Latin word for nuisance is nocere, which means to cause harm. Nuisance is an injury to the right of a person's possession of his property to undisturbed enjoyment of it and results from an improper usage by another individual. So बेसिकली न्यूसेंस होता है कि अगर आप किसी को हार्म पहुंचाते हैं या किसी के लाइफस्टाइल में आप इंटरफेयर करने की कोशिश करते हैं तो बेसिकली न्यूसेंस सिर्फ इतना होता है या फिर आप किसी को अनॉय करते हैं तो दैट मीन्स न्यूसेंस. तो इसके लिए अभी हम आगे विल सी द डेफिनेशंस ऑफ न्यूसेंस बाय वेरियस थिंकर्स. First of all, according to Stephen, nuisance is anything done to hurt or annoyance of the tenant of another, or of the land, one which doesn't amount to trespass. According to Salmon, nuisance consists in causing or allowing to cause without lawful justification the escape of any deleterious thing from one's land from anywhere into the land in possession of the plaintiff, such as water, smoke, heat, electricity, etc. So now we'll look at the essential elements of nuisance. The first thing is the wrongful act. Any act which is done with the intention to cause the infringement of the legal rights or another is considered to be a wrongful act. Damage or loss or annoyance caused to another individual. Damage or loss or annoyance must be such which the law should consider as a substantial material for the claim. So there now let's see the kinds of nuisance. So the first kind of nuisance which we are going to look upon is the public nuisance. In Indian Penal Code defines nuisance as an act which causes any common injury, danger or annoyance to the people in general who dwell or occupy the property in the vicinity or which must necessarily cause injury, obstruction, danger or annoyance to the people who may have occasion to use any public right. Public nuisance affects the society, the people living there at large, or some considerable portion of the society, and it affects the rights which the members of the society might enjoy over the property. The act which seriously affects or interferes with the health, safety, or comfort of the general public is the public nuisance. Instances where the individual may have private right of action in respect to a public nuisance. First thing is he must show the existence of any personal injury which is of a higher degree than the rest of the public. Second thing, such an injury which has to be direct or not just a consequential injury. Third point is the injury must be shown to have a huge effect. Now, the second kind of nuisance which we are going to look upon is private nuisance. Private nuisance is that kind of nuisance in which a person's use or enjoyment of his property is ruined by another. It may also injuriously affect the owner of the property by physically injuring his property or by affecting the enjoyment of the property. Unlike public nuisance, in private nuisance, what happens? An individual's usage or enjoyment of property is ruined as distinguished from the public or society at large. The remedy for private nuisance is a civil action for damages or an injunction or both. Now, elements which constitute a private nuisance. First, the interference must be unreasonable or unlawful. It is meant that the act should not be justifiable in the eyes of the law and should be by an act which no reasonable man would do. Second, such interference has to be with the use of enjoyment of land or of some rights over the property, or it should be in connection with the property or physical discomfort. Third, there should be severe damage to the property or which the enjoyment of the property in order to constitute a private nuisance. Now we'll have a look on a case law, Rose versus Miles, 1850. The defendant had wrongfully obstructed a public navigable creek, which obstructed the defendant from transporting his goods through the creek, due to which he had to transport his goods through land, because of which he suffered extra cost of transportation. It was held that the act of the defendant had caused public nuisance, as the plaintiff successfully proved that he had incurred loss over the members of the society, and he and uh, this he had a right of action against the defendant. So a nuisance may be in respect of the property or physical discomfort. First, property. In the case of nuisance with respect to the property, any sensible injury to the property will be enough to support an action for the damages. Second, physical discomfort. In a suit of nuisance arising out of physical discomfort, there are two essential conditions required. First, the condition is the excess of the natural and ordinary course of enjoyment of the property. The usage by the third party should be out of the natural course of enjoyment from one party. Second is interfering with the ordinary conduct of human existence. The discomfort should be of such a degree that it would affect an individual in the locality, and people would not able to put up or tolerate with the enjoyment. Now again we will have a look on a case study named Radheshyam versus Gur Prasad in 1978 or 86. Mr. Gur Prasad Saxena and another filed a suit against Mr. Radheshyam and five other individuals for permanent injunction restraining the defendant from installing and running a floor mill in the premises occupied by the defendant. So, Guru Prasad Saxena filed another suit against Radheshyam and five other individuals for a permanent injunction from running and continuing to run an oil expeller plant. The plaintiff has alleged that the mill was causing a lot of noise, which in turn affecting the health of the plaintiff. It was held that by running a floor mill in a residential area, the defendant was causing a nuisance to the plaintiff and affecting the health severely. So now, what are the now we'll have a look on the defenses which are available in nuisance. So there are many defenses available for this action. The first one is prescription. A prescription is a title acquired by use and time, and which is allowed by the law. A person claims any property because his ancestors have had the possession of the property by law. Prescription is a special kind of defense, as if a nuisance has been peacefully or openly been going on without any kind of interruption, then the defense of prescription is available to the party. On the expiration of the term of 20 years, the nuisance become legalized as if it had been authorized, and its commencement by a grant from the owner of the land. The essence of prescription is explained in Section 26 of the Limitation Act, in Section 15 of the Easement Act. There are three essentials to establish a person's right by prescription. They are: first, use or enjoyment of the property. The use or enjoyment of the property must be acquired by the individual by law, and the use or enjoyment must be done openly and peacefully. The second point is identity of the thing or property enjoyed. The individual should be aware of the identity of thing and property which he or she is peacefully or publicly enjoying. Third point is it should be unfavorable or the rights of another individual. The use or enjoyment of the thing or property should be in such a nature that it should be affecting the rights of another individual, thus causing a nuisance. And even after knowing of such a nuisance being caused, there must have been no action against the person causing it for at least 20 years. Second is statutory authority. So when the statutes authorizes the doing of a particular act or the use of the land in a way, all the remedies, whether by action or indictment or charge, are taken away, provided that every necessary reasonable precaution has been taken. The statutory authority must be either absolute or conditional. When there is an absolute authority, the statute allows the act, and it is not necessary that the act must cause a nuisance or other form of injury. Sorry. Whereas in the case where there is a conditional authority, the state allows the act to be done only if it can be done without a causation of nuisance or any harm in any form of the injury. So what are the remedies of nuisance? Now let's have a look on the remedies of nuisance. So mainly there are three kinds of remedies available in the case of nuisance. These are: first is injunction. An injunction is a judicial order restraining a person from doing or continuing an act which uh, from continuing an act which might be threatening or invading the legal rights of another. It may be in the form of temporary injunction, which is granted on for a limited period of time, which may get reversed or confirmed. If it's confirmed, then it takes the form of the permanent injunction. Second is damages. The damages may be offered in the term of compensation to the aggrieved party. These could be normal damages. The damages to be paid to the aggrieved party is decided by the statute, and the purpose of the damages is not just compensating the individual who has suffered, but also making the defendant realize his mistake and deter him from repeating the same wrong done by him. Third, defense is abatement. The third remedy is abatement. Abatement of nuisance means the removal of nuisance by the party who has suffered without any legal proceedings. This kind of remedy is not favored by the law but is available under certain circumstances. This privilege must be exercised within a reasonable time and usually requires notice to the defendant and his failure to act. Reasonable Reasonable for may be used to employ the abatement, and the plaintiff will be liable of if the action go beyond nuisance and trespass. Now we will see the difference between nuisance and trespass. Trespass on one hand is the direct physical interference with the plaintiff's possession of the property through some material or tangible object, whereas in the case of nuisance, it's an injury to some rights of the possession of the property but not the possession itself. Trespass is actionable per se, whereas in the case of nuisance, only the proof of actual damage to the property is required. For example, simply entering on another individual's property without the owner's consent and without causing him any injury would be trespass. Whereas if there is an injury to the property of another or any interference with his enjoyment of the property, then it will be amount to a nuisance. Now, if the interference with the use of property is direct, then the wrong is trespass. Whereas, if the interference with the use of enjoyment of the property is consequential, then it will amount to a nuisance. For example, planting a tree on someone else's land without amount would amount to trespass. Whereas, if a person plants a tree on their own land, then grows out to the land of another, would amount to a nuisance. For this also we are having a case law named Ushaben Naveen Chandra Trivedi versus Bhagyalakshmi Chitramandal in 1978. In this case, the plaintiff has sued the defendant for a permanent injunction to restrain the defendant from showing a movie named Jai Santoshi Ma. It was said by the plaintiff that the contents of the movie significantly hurt the religious sentiments of the people belonging to the Hindu community, as well as the religious sentiments of the plaintiff, as the movie showed Hindu goddess Lakshmi, Parvati, and Saraswati to be jealous of one another and were ridiculed in the film. It was held that hurt of religious sentiments was not an actionable wrong. So the conclusion for this, what it comes out is the concept of nuisance arises commonly in everyone's daily life. In fact, the Indian courts have borrowed quite a lot from the English principles as well as from the decisions of the common law, along with creating their own precedents. This has helped the concept of nuisance in the field of law to develop quite intensively and assure the fairness and well-being of all the parties which may be involved, as in the case of private nuisance, the party which is being affected, as well as in the case of public nuisance where the society at large is being affected. So by this, I end this video here. Thank you so much for your patient listening, and I wish you all are safe at your homes. So stay safe and stay healthy. Thank you so much.